To answer your question, still doing something.
Good afternoon. The hearings officer is here.
Hi, we're ready to begin if you are.
Okay, let's go on the record. Um, we will go on the record now. The time is about 1:30 in the afternoon on May 9th, 2025. This is the hearing for Deschutes County file numbers 247-24-240097 PA, 247-24000098 ZC, and 247 25000021 MA. My name is Gregory Frank, and I am the hearings officer that's been assigned to this matter. We'll talk about that shortly. Before we turn to the particulars of the hearing, I would like to turn things over to Ms. Stewart to describe how the electronic and hearing process is going to work. Ms. Stewart.
Good afternoon. For the record, my name's Audrey Stewart, and I'm an associate planner with Community Development. The item before the hearings officer is a comprehensive plan amendment to change the designation of the property from agricultural to rural residential exception area, and a corresponding zone change to rezone the properties from exclusive farm use to multiple use agricultural. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing. This will be followed by a brief presentation on the application. The county has established the following time limits for testimony: 30 minutes for the applicant, 10 minutes for public agencies, 3 minutes for the general public, and 10 minutes for the applicant's rebuttal. However, the hearings officer can modify or eliminate these time limits. When the testimony portion of the hearing begins, the applicant will present first, followed by public agencies, and next people in support. Then those in opposition will testify, and anyone neutral to the applicant's request will testify last. Afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony, and finally, staff can make any closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet. I will use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front here before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When hearings officer Frank asks if anyone attending remotely would like to testify, you'll need to use the raise hand button feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please submit your written testimony to me after your oral testimony. If you're participating remotely, you can submit your testimony to me via email at audrey.stewart@deschutes.org. Hearings officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Are there any objections to the format of the hearing? If you're attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn the hearing back over to Hearings Officer Frank.
Thank you, Ms. Stewart. Before we get going any farther, I'm just kind of curious as to what the numbers of participants or potential participants are, both in the hearing room and remotely. As you indicated, there's a possibility of time limits, and I'm just kind of curious as far as how many folks we've got.
In addition to the applicant's team, we have one person in person who signed up to testify.
Any remote?
We don't have anyone remote who's here to
Okay.
testify.
All right, so at this point in time, we'll talk about the time limits just shortly, but I'm going to suspend any time limits. But I do reserve the right to talk to anyone who is testifying and curtail their testimony or redirect it to appropriate matters. With that in mind, thank you, Ms. Stewart. As Ms. Stewart described, we are following the normal hearings procedures in the county code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. I ask for your patience as we make sure we get through each of the steps just outlined by Ms. Stewart. The application is being considered through the quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They are also set forth in the document prepared by staff, which we generally refer as the staff report. The public notice and staff report are posted on the county's website. They are also available directly from staff upon request. It is important that you direct all your testimony and standards or to the standards. So let me rephrase that. It's really important that when you testify that your testimony is related to relevant standards and applicable criteria. Basically, it has to apply to the law that dictates how I make a decision. If you believe a criterion applies, or a rule applies, or a law applies that was not listed, you may address the unlisted criteria, law, or rule. However, I urge you to also explain why that criteria, law, or rule must apply, and to do so with specificity so that other participants may respond, and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants in this hearing to respond means you can't do it, precludes your ability to appeal the issue to the Oregon Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, which may or may not apply in this case, with enough detail to allow me to respond to the issue in my decision precludes an action for damages in circuit court. As I just noted, I serve as a county hearings officer in this matter. I've been assigned. And in that role, my job is to be a neutral decision maker. Thus, while I have had contact with the county to serve in this role, I'm obligated to remain impartial, and I do not represent the county's interests or the interests of any participant. To that end, I will state for the record that I do not have any relationship with the applicant, any applicant representative that I'm aware of, and I am not aware of any connections that I may have with other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff, but only discussed the particulars of today's hearing. And the particulars that I'm talking about are scheduling almost exclusively. But I have communicated regarding scheduling, and I have not talked to staff regarding the substance of this application. I do not have any ex parte contacts to disclose. It is my obligation to preside over this hearing in an efficient and objective manner. At this point, I would like to ask whether or not there is anyone present who challenges or would like to say you should not be the hearings officer. So with that, Ms. Stewart, could you repeat my request and ask the folks to identify themselves if they object to me continuing to be hearings officer?
Is there anyone in the room who would like to object to hearings officer Frank serving as hearings officer? No one in the room has raised their hand.
Okay, thank you. Hearing none, I will turn it back over to Ms. Stewart to deliver the staff presentation. Shortly thereafter, we'll get into the applicant testimony, support testimony, and opposition testimony. So, Ms. Stewart, the floor is yours.
Thank you, hearings officer. I'll now provide more information on the application at hand, which is a comprehensive plan amendment and corresponding zone change. The subject property consists of 4 parcels, which have a combined area of approximately 240 acres. The parcels are located to the east of Bend, to the north and south of Highway 20. The property is located approximately 0.26 miles to the east of the City of Bend's urban growth boundary. The subject property consists primarily of undeveloped land, but contains 1 single-family dwelling and a photovoltaic solar farm, which encompasses about 62 acres. The applicant is requesting an amendment to the Deschutes County Comprehensive Plan designations for the property. They're requesting a change from the current designation of agricultural to rural residential exception area. The applicant also requests a concurrent change in the zoning designation from exclusive farm use, Tumalo-Redmond Bend subzone, to multiple use agricultural. The applicant has not requested an exception to statewide planning goal 3, agricultural lands, on the basis that the subject property does not meet the definition of agricultural land. The applicant submitted a report from Andy Gallagher of Red Hill Soils, which relies on soil maps created by the Natural Resources Conservation Service, and concludes that the property consists predominantly of Class 7 and Class 8 soils. Staff has received several public comments, which I've summarized here. As of this afternoon, a total of 6 public comments have been received. Key concerns raised in these comments against the application were increased density in construction, traffic, impacts to wildlife, the spread of urban uses, and a nearby gas pipeline. 2 of the letters that were sent in asked for more information on the intended use of the property under the proposed MUA 10 zoning. This is the link to the public record for this application, and all materials received as of 1 p.m. today have been uploaded. This includes some supplemental application materials that were submitted this afternoon by the applicant, which have been uploaded. I also want to note for the hearings officer that Central Oregon Land Watch provided some written materials which will be uploaded after the hearing. And with that, staff is available for any questions from the hearings officer.
Thank you, Ms. Stewart. I do not have any questions. Let me make just one real brief statement, and then we'll go to the applicant testimony. So the applicant or applicant's representative should come up and be prepared to testify. I have reviewed the documents in the file as of yesterday. Okay, as of yesterday. So that means quite clearly, I hope, that I haven't reviewed the materials that have come in today. So if you presume that I have already seen those, that presumption is incorrect as related to today's submissions. With that then, who's going to be testifying on behalf of the applicant?
Good afternoon, hearings officer Frank. Christopher Koback, K-O-B-A-C-K, 937 Northwest Newport Bend. I'll be testifying on behalf of the applicant this afternoon.
Go ahead, sir.
All right. Well, Ms. Stewart did an excellent job of telling you what the application is about. It's a plan designation change to RREA and a zone change to MUA 10. You may, from other cases, be aware that this area is on the east side of Bend. Most of the properties there are either east of Hamby Road are either MUA, which is becoming the predominant zone, or EFU. A lot of pre-existing development, a lot of zone changes. I consider them a lot in the last 5 to 8 years, going from EFU to MUA 10, all based on kind of a similar theme we have, which is under state law, a zone change is allowed, or the county is allowed to do one if without a goal exception if the land does not qualify as agricultural land. And that's been the basis for a lot of the recent activity. In this case, what we've done in our application is we went through and did DCC 18.136020, which is the 4 county factors. The first one requires you to demonstrate compliance with the comprehensive plan. There's some gloss put on that in prior decisions where the county board has said you only are required to address the relevant ones, the applicable ones, not the general policy statements. That's what we did. Staff concurred that we hit the right ones, and our explanations were acceptable to staff. None of the comments that you received to date have commented on that. Nobody's objected to what we've stated in the application. Before the hearing, we were handed with a 20-some page letter from Central Oregon Land Watch. To the extent they disagree with us on that, I don't know. I haven't had a chance to read it all. And we will during an open record period, which I'm going to request at the end of this. The second criteria is you have to address consistency with the purpose for the MUA 10 zone. We've done that again, other than perhaps what Central Oregon Land Watch has said. Nobody has objected or disagreed with our assessment there. We have to look at can the property presently serve the public health, welfare, and interest, and you consider some factors like availability of public services and then impacts on surrounding properties. Again, subject to what Central Oregon Land Watch may have said, nobody disagreed with our assessment under that criteria. And then the last main county criteria in subsection D requires you to assess whether there was a mistake in the zoning originally or whether there's been a change in circumstances. We've explained how there's really both here, and this is consistent with other applications that preceded us, is when the original zoning was put on, the agricultural determination was made with a broad brush, and it was done without the same level of information and specificity that we have now. There's been a lot in the past few years that have shed light on the quality of the soils in that area, and it does appear that the original designation in the 70s probably wasn't quite accurate, and based on the soils that are there on the site. And so there's probably been a mistake. More importantly, there's been dramatic changes. Farming has changed, the cost of farming has changed, and we've got that in our application explaining how infeasible it is to make money farming now in general, but particularly when you have class 7 and 8 soils that require massive fertilizer, water sources that aren't available on this property. It's just, there's been a lot of changes, and then the development pattern, there's giant solar farms in the area, there's a Christian Life Center across the street that takes up a massive amount of property, there's public utility facilities. The development pattern in the area has also contributed to the change that affects the ability to farm this property. And so we've addressed all that, and again, subject to what Central Oregon Land Watch may have said in its recent letter, there's been no disagreement with our assessment of that. The next thing I want to briefly talk about is the state regulations that do allow the county to rezone property that is not agricultural land without taking a goal exception. And you start with the mapping, which is really our source. We rely almost exclusively on the mapping. And the mapping in general shows that the land is predominantly not farmland. But it was a little complicated because the 58C soil is a composition where most of it is poor soil, but based on the National Conservation Resource Mapping, there's a 20% of that is class 6. So we had a professional soil scientist, Andy Gallagher from Red Hills, to basically just put more detail to the mapping and explain. He broke out every percentage. And then there's 5% of something called an inclusionary something or another, which doesn't really have a designation. And so he exercised his professional judgment. He just divided that equally among the various soils. So there's 5% of that, and he would put a percentage with the class 6, a percentage with the class 7, and a percentage with the class 6. And We believe that's the professionally appropriate way to do it. And again, subject to what Central Oregon Land Watch may have said, we didn't hear any disagreement with that from the county or from opponents. The one argument that I did briefly note in the letter that was given to me a few minutes ago is whether or not the soil information that Mr. Gallagher did had to be submitted to the state. You'll see in the file there is a comment from the state, and which is appropriate here because every zone change has to go to the state. There's a notice to the state, and they get an opportunity to weigh in on the application. And in this case, DLCD has not made any comment on the need to review Mr. Gallagher's report. And I think it's for a good reason. When you, and I'm sure you've seen these more detailed reports in other rezonings, perhaps in the Bend area. If the maps don't help you, if the maps don't get you where you need to go to this 51%, other applicants have, like the Markin case, and I think maybe the one up at the parks. Other applicants will go in and they'll get a scientist to come in, a soil scientist to come in and do a site-specific study where they actually bore soils and they do a very detailed assessment. And they can demonstrate that even if the maps don't get you to 51%, the site-specific test or analysis can get you to that. And there have been a number of them been approved on that basis. Well, in that case, I would agree that those soil tests have to be submitted to the state. That's the purpose of that rule. When you have a report that merely explains and edifies the existing mapping, we don't believe that is required. We'll address that more during the open record period because it is in Central Oregon Land Watch's letter. But that's our position on that. And again, DLCD got notice of everything. They've actually chimed in on this application, and they haven't said that they need to see it. Lastly, we've addressed the statewide planning goals as required. The only two that I want to talk about today are Goal 5 and Goal 14. Goal 5, in my experience, there has been a change in Deschutes County. In February, there was a hearings officer decision on the Cascade Academy where they interpreted the recent Luba case to say that if you're changing zones and you're introducing uses that weren't allowed at the time of the 1992 county inventory, you have to do an ESEE for those uses. And so we did it. And you have it, you'll see it in the record. It's very detailed. I don't like to invent the wheel or reinvent it. So I looked at what was recently done on some applications, particularly the scenic, because the only resource we have is the scenic corridor. And that was similar to the application up on Highway 97. And so I think you'll find it to be equally detailed to that one. And that one was accepted by the county board, and I think they were very complimentary of that form. So I think I picked a good one to use as my exemplar. And then finally, Goal 14. I know we're going to have a little bit of debate in writing on that because Central Oregon Land Watch does take the position consistently that this type of application requires either exception of Goal 14 or some analysis under Goal 14. The county board and the hearings officers of the decisions that I've read recently have consistently rejected that argument, and LUBA has rejected it recently as well, because the uses allowed under MUA 10 are considered rural uses, not urban uses, and therefore a change to MUA 10 does not result in urbanization of rural lands. And so we'll address that more in writing as needed. But I think that issue has been fairly well settled recently in Deschutes County. So unless there are any questions from you or staff on our presentation, what we'd like to do is request that you keep the record open for the 777-day period and allow us to respond to what came in this afternoon.
Okay. All of the points that you've made, well, let me step back. This is not my first particular rodeo with respect to plan amendments and zone changes dealing with properties on the east side of Bend. So a number of the cases you're referring to I've heard and considered and made decisions on. And so I agree with you in general, your comments regarding your general comments regarding the agricultural land, both at the county code level and the state level. So generally, I'm pretty on board. The one thing that I haven't read is your soil scientist report. Okay, I did not read that. I did read a number of things in the file, but I didn't read that. And one of the comments that staff made was that requested that I do is make a decision or some findings related to whether or not um, the soil study was adequate. And I'm just going to be candid, as you know, that I tend to be in a lot of these cases. I've not been in a situation which I call it your plan B, is you have a soil scientist report that talks about the existing mapping, but is not an on-site intensive relook at the property. So this is new. This is new to me. I'm not saying I can't figure it out. I'm not saying I can't understand it. What I'm telling you is I've not been in the situation where we had a soil scientist not do an on-site study and basically contradicts actually, is it refines the earlier mapping and clarifies it in the context that the majority of the land is 7/8 or whatever. So I'm just letting you know that, I'm letting you know that because my guess is that anyone else who is interested in this case, including Central Oregon Land Watch, is also going to hear my comment. So I'm not doing it just for your benefit, but I just wanted you to be aware when during your open record concerns and comments that you take that in mind. The other thing that I haven't, and it may just be that I'm still catching up. My guess is you've probably spent more than 2 hours prepping for this case, both in the application process as well as getting ready for this hearing. Most hearings officers don't spend much more than 2 to 3 hours getting a review of the file before a hearing, and I will tell you that's certainly my case here. There is a letter. It's really old, but the comment was included in the staff report regarding the transportation planning issues and the worst case scenario discussion that was had by you, the applicant, and additional clarification on that either now or in the open record period, just to say, hey, you're not looking at the right thing. You know, your brief review didn't go far enough. Take a look at this. I'm open to that. I'm also open to Central Land Watch or the staff indicating to me that this is an important issue and should be looked at with careful eyes. So those were the couple issues. You do not have to respond at this point in time. You may do so during the open record. We will keep the record open in the 777 style, and so you will have ample opportunity. You've appeared before me enough times to know that what comes in during the open record is reviewed by me carefully. I mean, really carefully. I have a saying in some of my hearings that what's in writing it has about fivefold impact compared to what is the oral testimony. Only because I take a look at it and review it and put it on my wall and then try to figure out if it's right or wrong. So I'm just letting you know those issues you can talk about now or later.
I'll probably do a little bit of both. I have in front of you, and I know you're very careful and meticulous about reading everything in the file, and I kind of pride myself in being meticulous about addressing the issues that my clients need me to address. So we'll do it both. On the traffic, I did want to explain that, and I know it'll be obvious when you go through the file. Staff, through Planner Rawlings, had some initial concerns about the first worst case scenario that report that Mr. Ferguson did. And we had it's great. And working with Deschutes County, as you probably know, is usually a pretty good experience. So we had a conference with him. He explained to Mr. Ferguson and myself exactly kind of what he needed to see. We went back and did that. We had a follow-up with him on one or two little minor things that he wanted to see, did that. And in Mr. Rawlings' last report, he agreed that Mr. Ferguson applied the proper methodology as required under the state regulations and accepted that report. So you have to read through the history, but the last communication you'll see the county traffic planner agreed with the assessment that Mr. Ferguson put together. And I haven't been able to read the 20-some pages I got a few minutes ago, but I didn't immediately notice a transportation planning issue in there. If it is in there, you'll hear from me in writing. On the application material, when you're going through this, as you always do, the burden of proof in this case wasn't put together overnight. It's detailed, and I think you'll find it to be very informative. There's a modification application which reduced the acreage a little bit, and then that's where Mr. Gallagher's report comes in. And there's a little bit more refinement of how his report addresses and implicates some of the original stuff from the burden of proof. Not a lot. It's really just to kind of explain what he did and how it relates to what we already submitted to you. So I think you'll find both of those documents to be helpful in reviewing this. And so that's all I really want to say at this point on your questions, and I appreciate them. I agree that the type of report we did here is not what you're typically seeing out there, maybe not what you're typically seeing in other rezones in other areas of Deschutes County, but we believe it's the appropriate way to proceed, and we'll explain that more in writing. Thank you.
Thank you. So anyone else wishing to testify on behalf of the applicant? Is there any public? I'm sorry.
Hearings officer, no one else in the room is testifying on behalf of the applicant.
Okay. Do you know if there's going to be any public agency testimony?
There's no public agencies here.
Okay. So general public testimony. Anyone here in support of the application?
No, hearings officer.
Anyone here in opposition to the testimony or to the application?
We have one person here.
Okay, if that person would come forward, be prepared to give first and last name and address, I'd appreciate it.
Good afternoon, Hearings Officer Frank. It's good to see you again. My name is Robin Hayakawa. I'm the Associate Staff Attorney for Central Oregon Land Watch, and our address is 2843 Northwest Lolo Drive, Suite 200, Bend, Oregon 97703. Want to start by thanking you for hearing public testimony on the application today, the work of Audrey, staff, getting us prepared. We do oppose the proposed plan amendment zone change from EFU to MUA 10. I submitted written comments that you'll have a chance to read here shortly, but I do want to highlight a few key points during this hearing. So I think the first one has to do with the subject property's consistency with the MUA 10 zone. As you probably know at this point, DCC 18136.020 requires that the public interest be best served by the rezoning of the subject property. And it goes forth and asks the county to look at a couple different factors, A through D. I think that the requirement that the public interest be, quote, best served is key here because it means that the rezoning needs to be better than the current zoning designation, not just for the property owner, but for the public at large. So one of the factors that is referenced in that code provision, subsection B, provides that the, quote, the change in classification for the subject property is consistent with the purpose and intent of the proposed zone classification. So we take this to mean that we need to look at the subject property and its characteristics and see if it is well suited for the MUA 10 zone. I think here the answer is clearly no. tax lot 100, which is, I believe, like the northeast portion of the subject property, is developed with a 63-acre solar farm. And, you know, that's one thing on its own, the creation of a substantial non-conforming use through the zone change, because solar facilities are not allowed conditionally or outright within the MUA 10 zone. But I think another important consideration to ask is, why is there a solar farm on the subject property, a solar facility? And the answer is that the subject property is in the midst of a substantial transmission corridor running north to south. It comes from Redmond, heads on south, it runs through the BPRD property, which you're familiar with, along the eastern edge of Bend. The other reason that the subject property is developed with a solar farm and that 3 other nearby tax lots also have large solar farms is that there's a Pacific Gas and Light Company substation there. So I think one could argue whether rural residential living and transmission corridors and substations are compatible uses, regardless of whether or not they're non-conforming. But I think it's apparent that they create land use conflicts. I'm actually not sure where you're based out of, Hearings Officer Frank, but recently in Central Oregon, we've been seeing communities beginning to organize and have concerns about the Blueprint South transmission project. This is a Pacific Core project running a 500 kilovolt high transmission wire from Redmond down to Klamath Falls. And as you'll see in some of my written comments, Route A, option A for this transmission project is directly through the subject property. I believe at least part of that consideration is the existing transmission lines, as well as the substation and the renewable energy facilities in the area. My point in bringing that up is that a rezone to MUA 10 here, at best, is just destining this subject property for more land use conflicts in the future. MUA 10 is supposed to provide efficient and orderly transitions, not more land use conflicts, but also at worst, it could end up being a real obstacle to needed transmission upgrades in the future that may best serve the public interest. So we don't believe the property is consistent with the MUA 10 zone's purpose and intent statement. We think you should recommend denial under DCC 18136-020B. And I have other thoughts about it I hope you can consider through my written comments. The second thing I'd like to address is the soil study. The assessment from Mr. Gallagher and Red Hill is a soil assessment under state law, but one that has not been certified by DLCD. OAR 660-033-00305B says that if a person concludes that more detailed soils information would assist a county to make a better agricultural land determination, the person, quote, must request that the department arrange for an assessment of the capability of the land. Here, we have Mr. Gallagher providing more detailed information in order to assist the county in making an agricultural land determination. He's interpreting soils maps. He's explaining the capacity of certain Gosney rock outcropping desk complexes, 58C. And I think really importantly, he's providing methodology to determine the predominance of the soils of the subject property. My point here is that state law doesn't allow this unless the soil study is certified by DLCD. OAR 660-033-00305D says, quote, only those soils assessments certified by the department under Section 9 of this rule may be considered by local governments in land use proceedings described in subsection C of this section. It's laying it out pretty clearly there. We believe that to the extent you find the soils assessment convincing, and I actually think it's a good thing you haven't read it, because we don't think that you're respectfully allowed to consider the contents of it based on state law. And it's not substantial evidence in this matter. Those are, I believe, some of the biggest deficiencies we see in this application. I appreciate your time, consideration, and I'm happy to answer questions if you have them.
Mr. Hayakawa, I appreciate your testimony. I'm going to read your submission carefully. Interesting concept with respect to the public interest. It's an interesting approach. Neither convinced nor the other side of it. Just find it interesting. And with respect to the soil certification by DLCD, that issue, I'm hoping that applicant has additional information so that I can weigh it against your comments and make a decision. But that's both points. What I'm trying to tell you, both points are welcomed by me for consideration. Anything else?
That's all I have.
Thank you so much. Good
Thank
to
you.
see you again. Anyone else wishing to testify in opposition?
There's no one in the room or online, hearings officer.
Okay, thank you. So applicant, any final comments before staff gives final comments? Then we'll talk about the open record, and I'll have Mr. Kobach, I'll have you just stay up there.
Thank you, Hearings Officer Frank. The applicant feels it's probably a little more efficient if we just respond to the testimony we just heard in the open record period.
Okay. Ms. Stewart, any comments?
No comments, hearings officer.
Okay, any concerns or issues with regarding Mr. Kobach? This is directed to Ms. Stewart. Any concerns or comments regarding the timing of the open record period?
Is that to me or to Ms.?
No, it's
Could you
to Ms.
clarify,
Stewart.
hearings officer?
It's to Ms. Stewart. I'm
Okay,
sorry.
thanks, hearings officer. I will provide some information on the hearings on the open record period. It sounds like the applicant has requested a 777, but I'll leave it to the applicant to confirm that.
Mr. Kobach? Is that correct?
Hearings officer, they're having a quick discussion about open record.
Okay. That's a disadvantage of not being there.
Seven and up. Yeah. You're the Hearings Officer Frank. Thank you for your indulgence. 7 days is sufficient for the applicants.
So as Ms. Stewart outlined, the 777 is your request with the dates I believe that she has on the overhead projector or the screen.
Correct. And if this is a good time, I do have some notes about submittals during that open record period. Please keep in mind that all submittals should be addressed to me. For email submittals, use my email, audrey.stewart@deschutes.org. The county does not retrieve information from a website link or personal cloud storage device. It's your responsibility to submit all evidence and testimony you want the hearings officer to consider. Any electronic submittals must be received by the county server by 4 p.m. Please do not wait until the last minute to submit your evidence and testimony. For a 777, the deadlines will be as followed. The open record period for new evidence and testimony will end at 4 p.m. on Friday, May 16th. The rebuttal period will end at 4 p.m. on Friday, May 23rd, and the applicant will have until 4 p.m. on Friday, May 30th to submit their final legal argument.
All right, thank you. Mr. Kobach, any questions regarding what was just relayed by Ms. Stewart, dates, times, and topics, open evidence, testimony, rebuttal, final argument?
No, sir.
All right, so the record will remain open. The public testimony, oral testimony will be closed today when I complete my comments. The open record comments will be submitted as described by Ms. Stewart by 4 p.m. May 16th for new evidence and testimony, by 4 p.m. on May 23rd for rebuttal, and final argument at May 30th, 4 p.m. If someone is questioning who anticipates submitting something during one of the first two record periods, that's the new evidence testimony rebuttal, and you're not sure exactly what new evidence rebuttal means, new evidence and testimony basically means everything's available, fields wide open. You can say what you want, subject to what I said earlier, that I will only consider relevant evidence to, or evidence relevant to relevant approval criteria and laws and rules. So new evidence testimony, kind of an open field. Rebuttal evidence and argument from anyone is basically intended to respond to what came in during that first 7 days. It's not brand new stuff. It's not, oh, I had never thought of this before. My preference would be that your rebuttal, comments, testimony, evidence, argument relates solely to whatever has been submitted during the first 7 days. That's my preference. And the final argument, if you're not the applicant, you don't get to do that. Under state law, the applicant in each and every case is given a final opportunity to present argument and argument only. And Mr. Kobach has experience with what that means, so I'm not anticipating any issues there. So he has the week after May 23rd until May 30th to submit his client's final arguments with respect to what's in the public record at that time. So are there any questions from staff regarding my final comment regarding the open record period?
No questions from staff.
All right, Mr. Kobach, any final question, any questions about comments that I just made regarding the open record period?
No, sir. Thank you for your time today.
Okay, and I'm just doing this because I as they say, whatever abhors the science and abhors the vacuum, well, I abhor or hate procedural issues. So, Mr. Hayakawa, you can just give affirmation from your seat if you don't have a problem, but do you have any problem with my comments regarding what is meant by new evidence, testimony, rebuttal, and final argument?
No.
No objections.
Okay, cool. All right, with that then, I appreciate everyone's civility. I appreciate everyone's comments and testimony today. I look very much forward to reviewing any submissions into the record of this case. This is a plan amendment, which means that I don't necessarily have a time limit on this, but my contract suggests that I have my recommendation to the board out in 21 days from the date the record closes. I'm just going to arbitrarily say the record will close on May 30th, despite whatever Mr. Kobach might want otherwise. But I'm telling, if he has a good argument that I'm wrong there, go for it. So 21 days from May 30th, you should receive my recommendation, and eventually this will go to the county commissioners for their review. Thank you so much for your testimony. I appreciate your attendance today. We will now close the oral portion of the public hearing. Thank you.
Thank you.
Boring.